Okay, let me call Debra Adimey versus Station Casinos LLC. If I could have the parties state their appearances for the record, starting with the plaintiff.
Good morning, Your Honor. Sarah Grossman Swenson, bar number 11979 for Plaintiffs Adimey et al. With me, I have my colleague Richard Treadwell, who's admitted pro hoc vice.
Okay, good morning.
Good morning.
Morning, Your Honor. Scott Mahoney for the defendant.
Good morning. All right, so I've got a couple of motions to dismiss, both filed by the defendant. So let me start with the corporate defendant's motion to dismiss. I will say that, if you want, I mean, I can have you argue the full motion, or I can just tell you kind of how I'm leaning and have you adjust your arguments based on that.
Leaning's fine, Your Honor.
All right. So what I am inclined to do is I'm inclined to deny the motion based on the fact. Let me just get to. Well, so let me first say a couple of things. So I know that there are the attachments that could potentially convert this to a summary judgment. There are a few things I wanted to address on that. I'm not sure that the essay on the history of hostility is something that I can really take note of. I mean, it's not something I have no idea who wrote it. I have no idea how it's authenticated. I don't know if it's necessarily even appropriate to attach to the motion. And I understand that there's the declaration from Jeffrey Welch, and there's just one W-2 form for defendant Adimey, but I note that this has to do with multiple plaintiffs, not just Miss Adimey.
Correct.
Right. So, and if I'm looking at the statute itself, under NRS 613.822, at this point, it says, employer means any business entity which directly or indirectly through an agent or any other business entity, including through the services of a temporary employment service, staffing agency, or similar entity, owns or operates a covered enterprise within the state, et cetera, et cetera. So at this point, I don't find that it would be appropriate to grant the motion to dismiss, because it appears that under the statute that the corporate defendants may be covered entities. Now, certainly if it gets to a point where discovery has really been more thorough and there is a motion for summary judgment later on, I would certainly consider that. But at this point, I'm not inclined to convert the motion into a motion for summary judgment, and I would only consider it as a motion to dismiss, and I'm inclined to deny it on that. So that's where I am on that motion. Then, as far as the motion to dismiss the plaintiff DeCarbo's retaliation claim, what I'm inclined to do is to grant in part, deny in part. So I would deny as to any of those events that occurred prior to August 31st, 2022, which is kind of the drop dead date that the statute covers. I would be inclined to grant as to any of the what's the word that I'm looking for? Adverse actions that were taken after August 31st, 2022. I know that there was a argument that that it would be inappropriate to add a cause of action for tortious discharge actions. I don't think I'm there yet. I would be inclined to grant leave to amend and then fully flesh out that issue if it becomes an issue. So that's what I'm inclined to do as far as that second motion to dismiss. So I don't know if you want to handle any highlights or arguments separately, or if you'd like to cover them all in one go. Mr. Mahoney, it's your motion, or they are your motion, so I'll certainly allow you to make that determination.
Okay, thank you, Your Honor. I'll start with the DeCarbo motion. I think that's probably simpler. We actually, we only sought relief for adverse employment actions occurring after the last effective date of August 31st, 2022. So we actually agree with the granting in part and denying in part. We think that's the way the statute's intended to operate. So I won't argue that any further unless Ms. Grossman Swenson has something else to add. And then on the leave to amend, I think the Nevada Supreme Court has been clear that that the public policy toward is supposed to be confined to rare and exceptional cases. It's already, among other cases, as we point out, rejected that in the context of a small employer that's below 15 employees and don't have the protections of the state discrimination statutes. Also granted it with age discrimination. We don't see why the Nevada Supreme Court would make an exception for an SB 386 retaliation claim, given its history with the other claims. And in particular, as pointed out in the Sabalos case cited in our brief, if the statute has already addressed an issue, the Supreme Court says that it's loath to interfere with what the legislature's done. I think here we have a statute where of limited duration was clearly intent. The SB 386 was intended to provide for a retaliation provision for adverse employment actions for a very limited period of time. That's expired, and I think the legislature wanted it for a limited period of time, and if it had wanted it something different, it would have said that the retaliation expires in 2027 or 2030 or something like that. So I respectfully think that this is not a situation that the Nevada Supreme Court would recognize a public discharge toward action, and so we'd ask the court to consider that. On the motion to dismiss the corporate defendants, as far as what the court calls the essay, that's something that the client wanted aired. Does feel that only the entity defendants and not Station Casino and the other two corporate defendants should be involved, but that's not necessary for the resolution of the case. We're not asking necessarily for the court to consider that, convert it based on that. But as to Mr. Welch's declaration, we would ask that the court convert it and treat it as a summary judgment motion. The statute is clear that the definition of employer is under SB 386 is to be a business entity or owns or operates a covered enterprise. There's various covered enterprises under the statute. Hotels and casinos are the only two that would apply in this particular case. Through Mr. Welch's declaration, we've made it clear that what we call the entity defendants, Boulder LLP or NP Boulder, NP Palace, etc., were the W-2 employers, but more importantly for SB 386, only the entity defendants owned and operated the casinos. So, for example, with first plaintiff Adimey, her W-2 is with NP Boulder. Per Mr. Welch's declaration, NP Boulder owns the real property on which the hotel and casino is situated. It operates the property, it holds the gaming licenses. So clearly we think that is the operating entity. Nothing in the plaintiff's motions, they haven't done anything to dispute that if it were treated as a summary judgment motion. They haven't provided, W-2 from any of the, I think it's 86, whatever the number is, plaintiffs showing that they're employed by one of the corporate defendants as opposed to the entity defendants. They haven't gone into the real property records and said, well, actually Boulder Station's owned by Station Casinos. It's not. They certainly could have done that. They've done nothing. I assume gaming records are also public. They've done nothing to show that, Station Holdco, for example, holds a gaming license. So we, our aim here is just to get the proper defendants in the case moving forward, and we just don't think there's any disputed material fact as to who owns and operates these properties. So we'd ask the court to reconsider the tentative ruling and convert this. And once converted, I think summary judgment is appropriate. Thank you, Your Honor.
Thank you, Mr. Mahoney.
Your Honor, I will respond briefly to Mr. Mahoney's points. I do think that you got your both rulings exactly right. So I certainly would on the DeCarbo retaliation claim. While I think perhaps it may have been well advised to have permitted the anti-retaliation provisions to go on for a longer period of time. We certainly understand the point of the literal language is sunsetting as of August 31st, 2022. I do think it's appropriate to permit us to amend to add a cause of action for wrongful termination, because of course it would be, I think, an absurd result if if it were to be found that the legislature intended that these thousands of Nevada workers had the right to return to work, but then as soon as the statute expired, an employer could fire them if they'd filed a claim. And I just don't think that that is the result the legislature intended. The cases cited by defendants are distinguishable, where the legislature has made a specific determination that employers of a certain size don't actually in fact have to comply with anti-discrimination statutes due to their very small size. And so that's a different situation than what we find ourselves in here, where certainly there was a clear public policy permitting workers to file these types of claims, and preventing retaliation against them for filing these types of claims is much more analogous to the workers' compensation anti-retaliation provisions that the Nevada Supreme Court has found do constitute protected activity that should be protected under the wrongful termination cause of action. So we would ask for leave to amend.
Okay, thank you. And then Ms. Mahoney, let me clarify one thing as far as the wrongful termination arguments. I'm not saying that what I am determining today regarding leave to amend is dispositive of that issue.
Understood,
I'm saying that it's a little premature until I actually see what's contained in the amended claims. And certainly Mr. Mahoney, you would be free to address those issues once they become relevant.
Okay, I understood, Your Honor.
Okay, but is there any other response that you would like to add, Mr. Mahoney?
No, I think it's all pretty much laid out in the brief.
Okay, great. So who would like to prepare the order?
Well, sorry, go ahead, Mr. Mahoney.
I was going to say, Your Honor, since you've finalized rulings on both motions, I would ask on the this SB 386. It's a new statute, and now it's a done statute, and there's a number of issues presented by the statute. I don't think the Nevada Supreme Court has made any definitive rulings on things. I know they have one case, Beza v. Boyd Gaming, where they're wrestling with some of the issues. I would like on the corporate defendant issue to have this certified under or deemed a final judgment under 54B in case the client decides to pursue that issue. I don't know if they will, but I want to preserve that option for them.
Okay.
And
Ms. Grossman, go ahead.
Your Honor, I'm sorry, I did not mean to interrupt you, but I think we would oppose 54B certification. I don't think it's appropriate here, given that Your Honor has ruled on a motion to dismiss and has made it clear that defendants can raise these motions again as a motion for summary judgment, if it is found to be appropriate based on discovery that does occur in the case. So
I'm sorry, Ms. Grossman.
Go ahead, Mr. Mahoney. So
I was just going to say, Your Honor, that I think it's important for clarity going forward. I mean, in this case, is it just again with talking about Plaintiff Adimey, if is it going to be NP Boulder that's deemed an employer? Is it going to be Boulder, Station Holdco, Red Rock Resorts, and Station Casinos? I think that's an important issue that might want to be clarified. Whether we're whether a whole chain of parent corporations can be liable under the statute or not. So
So let me do this because I really wasn't prepared, since there wasn't any filings or requests in the briefings regarding asking to certify this as a final judgment. If Mr. Grossman, if you'll prepare the order and run it by Mr. Mahoney to approve as to form and content, and Mr. Mahoney, if you would like to file a request regarding certifying it for the Supreme Court and brief that issue, then I can certainly do that. You know, and before I sign the order, I can make a determination as to whether or not it would be appropriate to certify.
okay, so just so I understand the procedure, you want we
So
submit the order, but then you'll essentially hold the order while we submit for the briefing, or I just want to make sure you understand how it works. Okay.
Yeah, so if you can agree to the language that's in the order. Well, actually, but don't submit it yet, and then, you know, once you have the language agreed upon, file your motion. And if you want, I can even put it on a expedited schedule. So that way we can make a determination as to whether the order itself is going to be certified or not.
All right.
And then once I make a determination as to that, then I can sign the order either certifying or not certifying.
Okay, that sounds like a good approach. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Thank you. All right. Have a good day.
Bye.
You too.